Good afternoon, everyone. Welcome to another live edition of Employment Law Q&A. My name is Alex Lucifero. I am an employment lawyer with Samfiru Tumarkin LLP. We are the most positively reviewed employment law firm in the country of Canada, and we have offices in Toronto, Ottawa, Calgary, and Vancouver. We're here this afternoon on a admittedly very gray, dreary Wednesday or Thursday rather afternoon here in Ottawa. Here to take your employment law questions live. We are here to help you resolve any workplace problems that you have. I'm an employment lawyer. I've been doing this for quite some time. I don't know much else about other areas of law, but I can tell you I know employment law very well. And again, as I said, we are here to help. And I see a couple of questions already trickling through. So before I get to the questions, a couple of items. First off, our contact information. If ever you have a question that you can't ask live on our Q&A, first place to visit, employmentlawyer.ca. That is our website, employmentlawyer.ca. It's got a ton of resources, a ton of blog articles, news articles, posts, really anything under the employment law sun is there. It should be your starting point for any concerns, for any questions you have with respect to employment law. And of course, it also has our contact information. If you want to email us and ask your question, send us a brief summary. It's completely confidential. Employmentlawyer.ca. Employment lawyer, or rather help at employmentlawyer.ca is the email address, help@employmentlawyer.ca. Again, send us a brief email. Tell us your problem. I promise you someone will be in touch. You also see our telephone number there, our 1-800 or 1-855 number on the screen. Give us a call. We have an entire intake team that is there to help guide you through that initial process of figuring out what concerns you have, what questions you have, and then putting you in touch with one of our employment lawyers. That's the contact information out of the way, guys. Again, our website, employmentlawyer.ca, our email address, help@employmentlawyer.ca, is how you get a hold of us. There are no bad questions when it comes to the workplace. There are no bad questions when it comes to employment law. Even if you feel like you're dealing with a small issue or you're worried about something in the workplace that's weighing heavily on your conscience, do not be shy to reach out. Actually, if you don't reach out, if you simply sit there in silence with respect to your employment law issues, you could be doing yourself a disservice. You could be doing yourself harm. As a quick example, someone who has been temporarily laid off, you don't want to sit on a temporary layoff and let days and weeks go by. You need to act on a temporary layoff right away. A temporary layoff may very well be a termination, in which case you would be owed severance. But the longer you wait, the more difficult that becomes. And so again, it's an example of not sitting on your problems as an employee in the workplace. Another interesting tool that we have is Pocket Employment Lawyer. PocketEmploymentLawyer.ca is another website you can reach. You answer a couple of questions and you will get a very quick assessment of your situation and whether or not you're dealing with, for example, a constructive dismissal, or whether you are owed severance or not in the event of a for-cause termination. Again, PocketEmploymentLawyer.ca. All right, guys, we've got the admin stuff out of the way. Let's get to your questions. Again, I already have a few coming through here. If you have questions about vaccination policies, if you have a question about COVID-19 health and safety in the workplace, this is an excellent opportunity to get some information, to get some advice. Once again, for those of you just tuning in, my name is Alex Lucifero. I'm an employment lawyer, managing partner at Samfiru Tumarkin LLP. This is a live Q&A. Go ahead and ask your question, and I will make sure to answer it. As always, and this is a rule of mine for these Q&A, everyone, I try and get, and I usually do get, to every single question that's asked. So please go ahead and fire it away. Let's get started. First in line. Batter up. Julie Walter. Thank you for your question, Julie. I was terminated before the vaccine was mandated and now I cannot come back unless I'm vaccinated. What do I do? Well, Julie, certainly you are owed severance if your employment has been terminated. And quite frankly, that's likely whether there was a vaccination policy in place or not in your workplace. And so, certainly, point number one is that, well, you're going to be owed severance if you were let go from your job. If you are a non unionized employee, your severance is going to be based on your age, position, and years of service. And listen, if you're even a short service employee, your severance is going to be significant. And so that's point number one. Now, if you cannot come back to work unless you're vaccinated, well, are you referring to that same employer, Julie, or to that same position? If that's the case, well, then again, you're still owed severance in a situation like that. Your employer doesn't necessarily have to have you back to work. So, for example, for those employees on an unpaid leave, those employees might be able to treat that as a termination in any event. And that's actually probably what you want to do in a situation like that. You don't want an employer to be able to put you on an unpaid leave of absence or suspend your employment without pay. If you're referring to other employment, Julie, and I have had this come up with clients before where the job search has gotten harder for unvaccinated employees because they're not vaccinated and because a lot of employers are actually requiring now vaccination as a term of employment in the actual hiring process. And that's very difficult, I have to say, Julie. If that's your situation, employers are, it looks like, allowed to require vaccination as a term of employment upon hiring. And yes, that potentially does reduce the pool of potential opportunities that you have as an employee that's looking for work. I would say, listen, do your best and make reasonable job search efforts. And not all employers are requiring vaccination as a term of employment. I know that firsthand from my employment law practice. And so I'm sure an opportunity will come up. But again, I think the main point here, Julie, is if you've been let go, again, whether that was with respect to a vaccination policy or not, you're going to be owed severance. It's important you know how much severance you're owed. And if you haven't been offered the right amount of severance, that is certainly something that we can assist with. We assist people every single day in resolving their severance package negotiations, and we do it quite successfully. All right, non-vax asks, I'm non-unionized. I work in a daycare located in a Toronto District School Board school that has mandated the vaccine. So I'm not entitled to severance pay. I'm put on unpaid leave. How long can they keep me on unpaid leave? Well, it's interesting you say that they've mandated the vaccine. It's a question of who's mandated the vaccine, non-vax. And so if this is an employer policy, in other words, if there is no government mandate in place with respect to vaccination, then that is something that you can likely dispute. You actually don't have to accept an unpaid leave for even a day or two. You can treat that unpaid leave as a termination and obtain your severance entitlements. Now, your employer might take the position that vaccination is a necessary term of employment, but that is an arguable point. The way the law currently stands is that if an employer has to require vaccination by way of a government mandate, so for example, in long-term care homes, the provincial government, at least here in Ontario, requires all employees of long-term care facilities to be vaccinated. And that means that if you are a long-term care employee and you're not vaccinated, well, then you will lose your job if you don't comply, and you wouldn't be owed any severance because that is a government mandate that the employer has no choice but to follow. But if it's the employer's choice to implement a vaccination policy, those employees that are put on unpaid leave or terminated from their employment are going to be owed severance. And non-vax, you should speak with one of our lawyers. Again, if I'm getting the facts incorrect here, if there is a government mandate in place, then that obviously changes the analysis, but that is the crux of the issue. All right, Lou Co asks, I was put on unpaid leave. How can I approach my employer and say that it's a wrongful dismissal and they owe me severance so that they do not consider it as if I quit myself? Excellent question, Lou. It's a difficult conversation to have. generally speaking, we actually won't advise employees to have those kinds of conversations on their own, simply because they're not productive. They're not particularly productive. If you as an employee go to your employer and say, hey, you're not allowed to put me on unpaid leave, I think I'm owed severance, I think most of you out there will agree, it's unlikely an employer will simply say, okay, well, let's bring you back to work. It's not likely to happen. That is why you need an employment lawyer in your corner to help resolve these issues. Now, does that mean that we as employment lawyers will go in, guns blazing, so to speak, and be overly aggressive and overly antagonistic? No, not at all. A lot of times it's about educating employers with respect to the legalities of what they're doing. And again, these vaccination policy issues, where either you've been placed on an unpaid leave or your employment has been terminated as a result of a vaccination policy, a lot of these depend on A, whether your employment is unionized or not. Unfortunately, we can only assist non-unionized employees. B, whether there is a government mandate in place. And for most employers out there is no such government mandate, at least in Ontario. And I can't speak to the other provinces in Canada, but in Ontario, the only industry in which there is currently a mandate is long-term care homes. If you are not in one of those two situations, we can likely help get you out of your workplace and get the severance entitlements that you are owed. It's important that you reach out to us and have a conversation with one of our employment lawyers. It has to be said, every case is different. Every case is context specific. There are a number of factors that we have to take into consideration when assessing your severance entitlements, when assessing your options. But regardless, the first step, always, 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 if you're dealing with any difficulty at work, including these vaccination policies, you need professional advice. You need to speak with one of our employment lawyers. Again, you can email us extremely easily at help@employmentlawyer.ca or visit our website at employmentlawyer.ca. Our contact information is all there. Send us a brief email with a description of the issues that you're having. I promise you someone will respond. All right, Joe asked, I appreciate the question, Lou. It's an important one. We're speaking with lots of people who have been put on unpaid leave as a result of vaccination policies. Joe asks, I understand that an employer can make minor changes to the employment contract without triggering a constructive dismissal. Another excellent question, Joe, and that is generally speaking true. And I think if you consider this yourself, you'll know this to be true. Terms of employment aren't necessarily written in stone. There has to be some degree of flexibility there, where if some of an employee's job responsibilities change, if you maybe have to take on something temporarily, if your position is going to change a little bit to add or take away a duty or a responsibility or two, I think it's normal. I think everyone would understand that that degree of flexibility has to exist. Otherwise, an employer can operate. That said, significant changes need the consent of the employee. And so when we start talking about things like major changes to an employee's position or significant changes to their pay, as the most obvious example, perhaps, well, that's when we enter the realm of constructive dismissal. Constructive dismissal basically being a breach of contract. When an employer tries to force a change upon you that has a real impact on your terms of employment, that is effectively a breach of contract. It allows the employee to reject that change and seek a severance package. So, Joe, you're right. A very small change, it's not going to be a constructive dismissal. You may have to go along with a small change like that. For example, if your employer changes your schedule by an hour, and let's say instead of asking you to work 9 to 5, they're asking you to work 8 to 4. Well, that's certainly a change. It's not necessarily a minor change. And so you might have to accept a term of employment like that and a change like that. If you are unsure as to the degree of change, if you feel like the change is a significant one, but your employer maybe is telling you that it isn't, again, and I hate to be repeating myself here, guys, but you need advice in a situation like that. If you feel as though the change is significant, before you say anything in response to your employer, before you accept or decline, give us a call. Speak with one of our employment lawyers. get tailored advice on your specific situation, and you will know exactly what options you are, exactly where you stand, and exactly what to do. Thank you for the question, Joe. All right, Tammy asks, I have serious medical crisis receiving treatment. My doctor supports postponement rather, of the WCAT hearing date. How can I get an extension? Just 2 weeks before the hearing date, the WAO just withdrew from representing me in addition. Tammy, you should write to whomever it is that you're dealing with, whether it's the tribunal or whether it's a particular arbitrator or judge or coordinator. Present them with a doctor's note advising that you are dealing with some health issues and advising that it is the doctor that is recommending the postponement. In other words, you need evidence from a doctor saying you cannot do this right now, or you cannot do this in 2 weeks' time. You need a postponement. With that doctor's note, with that evidence, it's, I would say, highly likely that you get the postponement. But they're not just going to take your word for it. You need the doctor's note. Just like, generally speaking, in the employment law context, if you require a medical leave of absence, or if you have to extend your disability leave, for example, an employer doesn't have the obligation to just take your word for it as the employee. They have the right to ask for a doctor's note, and you should certainly be providing one. All right. Dan asks, hello, under what circumstances can an employee take action against their union if they felt they weren't properly represented? I work in federally regulated business, being put on unpaid leave February 1st. Dan, thank you very much for the question. It's an interesting one, albeit a difficult one. The short answer to your question, Dan, is that it is very, very rare and very, very difficult for an employee to take action against their union. Actually, if this is, and you mentioned unpaid leave, so I assume you're talking about a mandatory vaccination policy. There was a case that I think just came out at the beginning of this week, might have been the end of last week, but very, very recently in the past few days, in which an employee did exactly that. They sought to claim that their union wasn't properly or fairly representing them on this issue of mandatory vaccination policies, and they ultimately lost. And I suspect that's how all, if not, the vast majority of these kinds of cases will go. I hate to say it. I hate to be the bearer of bad news. I think unions are excellent for many different things. I think they provide job security. I think they provide great pay and great benefits and a lot of perks. I think the one downside to unions is that you live and die by what the union decides on a particular employment issue. It is called a collective agreement for a reason. It is the union that is the employee's legal representative. You cannot go beyond those walls of the union. And if your particular union has decided that a vaccination policy is reasonable and they're playing ball with their employer on exactly those terms, then all of those unionized employees have to follow suit and have to play ball as well. Otherwise, you risk, as you mentioned, being put on leave and your employment coming to an end and potentially coming to an end without severance as a result. It's a tough spot, but that is the stark reality that you face. That in a situation like that, this issue may very well cost you your job and cost you any severance entitlements that you have. Again, for non-unionized employees, the analysis is very, very different. The analysis depends on whether there's a government mandate in place, your particular industry perhaps, etc. And for the vast majority of non-unionized employees, if you are let go because of a vaccination policy, then you are going to be owed severance. That might not be the case if you're a unionized employee and your union decides to go along with such a policy. Now, That said, guys, I want to give some employers their fair due. And obviously, we can't go into any particular details, but it needs to be said. There are lots of employers out there that are dealing with this issue of vaccination policies in a more reasonable way, where, for example, they provide rapid testing as an alternative to providing proof of vaccination, for example, or where perhaps there's no particular vaccination policy at all. And so it's not every single employer that has taken a hard stance on this issue. And to add to that, we have certainly been dealing with lots of employers who offer severance packages in these situations. And ultimately, if you're a non unionized employee and you've been let go because of a vaccination policy, that is ultimately what you are going to be owed. It's not necessarily, and there is an argument here on the basis of human rights, don't get me wrong, but ultimately the bulk, the vast, vast majority of an employee's entitlements, if they're let go because of a vaccination policy, are going to be severance. And again, there are employers out there that are letting employees go, albeit based on these vaccination policies, but are still doing the right thing and offering these employees reasonable severance packages. That is why, that is effectively what an employee's entitlements are in this situation. Now, if there is a medical issue at play, and that's the reason why an employee hasn't been vaccinated, or if there's a religious exemption at play, and perhaps the employee was let go in any event, well, then there is a question of whether there is a human rights violation in these kinds of cases. And there is potentially an argument that an employee would be owed both their severance entitlements and potentially human rights damages if there are actual grounds to pursue a human rights claim. That is a possibility as well. And we've seen a few of those cases as well, whether it's on medical grounds or whether it's on religious grounds. I'll get back to the questions there, guys. Sorry, I went on a bit of a rant. We've got about 8 minutes left on the live Q&A. I want to see those questions rolling. You've got, another 5 to 8 minutes or so. So by all means, go ahead. I saw some follow-ups, so let me address the follow-ups here. Just bear with me. So non-vax, I think you followed up and said, follow-up, the lawyer said because the TDSB, the Toronto District School Board, that's obviously a school board in Toronto, mandated it, and my employer had no choice to follow with the mandate. Interesting issue, non-vax. This is what we call a third-party requirement issue. And it has come up. It's come up in the construction industry. It's come up with certain technicians. And the issue is as follows. If it's not your employer instituting a policy, but rather a third party, another entity, it could be a client. In non-vax's case, it could be a school board. But if there is another entity that is requiring proof of vaccination for anybody that attends on the site or on the premises to be vaccinated, well, then that is a difficult situation. That is potentially what we call a frustration of employment. In that, well, it's actually not your employer's fault that they're not able to continue your employment. It's actually not your fault as well, for that matter. But because of this third party, because of this other entity that's requiring vaccination, your employer is no longer able to continue your job, no longer able to employ you. Now, do I think that should result in a termination without severance? No, I actually don't think so. I think maybe at worst it might result in a temporary layoff or in an unpaid leave of absence, perhaps, or hopefully in some sort of other accommodation where an employee is able to, for example, work from home. Now, I appreciate if you're in the childcare setting that might not be possible. But these third-party situations are a difficulty. They are a problem. Because again, if it is a client, for example, of a construction company, if you have to go on site at, let's say, a university, and the university is requiring vaccination, well, that poses a problem for those employees that are not vaccinated. And your employer is not necessarily on the hook and responsible to pay those employees severance because it's not their fault. It's this other entity that's requiring vaccination. So I certainly get it. It's a difficult situation. And if you've received advice from one of our lawyers certainly trust that advice and bank on the fact that it is correct. All right, we'll go back to Tammy, who initially asked about an extension and is now asking, my employer terminated me while I was on a doctor's certified medical leave due to the employer failure to accommodate, causing more injuries. They refused to pay severance. What can I do? Well, Tammy, that is a problem, because even an employee who's been on a medical leave for a couple of years, even 3 or 4 years for that matter, an employer may not be able to let them go. They may have to hold their job for that employee, if there's a chance that that employee might be able to return to work in the foreseeable future. So your employer didn't necessarily have the right to let you go just because you were on a medical leave. Tammy, not at all. And you would be owed severance in a case like that. And your severance entitlements might be your full severance entitlements based on your age, position, and years of service. Of course, the rationale there is the longer an employee has been with the same company, the older they are, the more senior or the more specialized their position is, the greater their severance entitlements are going to be. We're not just talking about a week or two's pay here. We can be talking about months and months and months of severance. If you are a long-term employee who is in their late 50s or 60s perhaps, you might be looking at 2 years of severance pay, as much as 24 months as a severance package. Now, Tammy, an important question would be whether you will ever be able to return to work or not. If there is no prospect of you returning to work in the foreseeable future, your employer may still be able to let you go. You would still be owed some amount as severance. This is assuming a few things. Number one, that you're in Ontario, because I'm talking strictly about Ontario employment law now. And number two, if, of course, your doctor is able to confirm that you are indeed unable to return to work for the foreseeable future. Now, again, those situations are usually reserved for long absences, long medical leaves of absence, where an employee has been off of work for perhaps 2, 3, 4, 5 years. I should also note, Tammy, because it sounds like you've already been through a couple of legal processes with workers' compensation. You have 2 years from the date of your termination to deal with severance. And you effectively have 2 years from the date of your termination to commence legal action against an employer. It's important you do that. If you've missed that 2-year deadline, you may very well be out of luck. And so if you've been let go from your employer and it's been quite some time already, you need to move on this immediately. Give us a call, send us an email, visit our website, and we will be able to point you in the right direction and give you the advice that you need. All right, we're going to start wrapping it up here, guys, but I'll answer the last couple of questions. If you have a question, if you need to get your workplace question answered, you've got a couple of minutes right now, but you can also reach us tomorrow at 1:30 with my colleague and friend, Samara Belitsky, who will also be doing a live Q&A for our Friday audience. All right, what might be the last question here? First Time Grow asks, if I'm on long-term disability benefits and have no money but need your assistance, can you still help, or how does this work? Excellent question, First Time Grow. Yes, for a lot of people, whatever your financial situation is, oftentimes we absolutely can help, and help for free. Many of the consultations we provide are free consultations. You can also email us with your questions, and we'll happily get back to you by email. I should add the caveat that if it's a very complicated situation, or if it requires a lengthy discussion, we do also have to offer paid consultations for those more complicated scenarios. But First Time Grow, do not worry about any financial concerns immediately. Give us a call, send us an email. You'll be in touch with someone from our intake team. They will be able to give you the advice that you need and set you up with, even if it's just an email, an exchange with an employment lawyer who can point you in the right direction, even if you're on long-term disability benefits. We will wrap it up there, guys, because it is just about 2:30. Thank you so much for tuning in. Thank you for asking your questions. If I've helped even just a few of you and point you in the right directions with respect to your employment law issues, I've done my job for the afternoon. This has been another great edition of Employment Law Q&A. Again, I'm Alex Lucifero. We are Samfiru Tumarkin, LLP. Wishing you all a great end to the week and an excellent weekend. We'll be back here tomorrow. Stay tuned. Take care, everyone.